In regards to elder financial abuse, are you seeing more cases like this?
Yes, unfortunately, we're getting quite a few of these cases.
What is the typical fact scenario with a case like this?
So in what we call elder financial abuse, the case almost always deals with an elderly person. They usually have dementia or some form of Alzheimer's or some diminished mental capacity because of their age.
And what kinds of documents might they be signing that would cause this abuse?
So the typical fact pattern is someone convinces the elderly person to sign a legal document, whether that's a deed, a power of attorney, financial documents such as beneficiary designations that causes assets to flow to the person that convinced the elderly person to sign these documents.
And who are the people convincing the elderly?
This is often, almost always in my experience, a trusted person. Many times it's members of that person's family. Sometimes it's what that person thought was a friend. Sometimes it's members of nursing homes who ingratiate themselves to the resident and convince them to sign documents giving assets to them. And sometimes, and I've had a recent case, it can be a newly found boyfriend or girlfriend that has come into the life of the elderly person.
What can you do to help?
As a lawyer, what I can do and what I do in these cases is I sue to void the transaction. That's the first thing I do. I want the court to either set aside the deed, void the power of attorney, or otherwise declare that the financial instrument has no effect. I will also sue for damages. Sometimes the money or assets have already moved and we need to get those back, so we'll sue for financial damages. The primary thing to do is sue to void the transaction. Now there's two major causes of action that I go for in these cases. The first is lack of mental capacity. Under the law, a person must understand the nature and effect of what he or she is doing involving business and legal transactions. If they don't, the court can set that aside. The second cause of action is undue influence, which is different than lack of mental capacity. Undue influence is when a person, a trusted person, abuses their position of trust and overcomes the will of the person who's being convinced to sign documents such that they no longer have their own free will and are essentially psychologically coerced into signing these assets or documents over to the trusted person. One thing that we also do is when we sue in these cases, it's important to move quickly. I typically file as soon as I have all reasonable facts at my fingertips. We sue, and we also ask the court to freeze assets so that we don't get assets moving around. If you believe that you have a loved one that has been the subject of elder financial abuse, whether you're the executor of his or her estate, you are now their guardian, or you are the previous beneficiary of their documents such as wills or financial accounts, and you believe that they have had their will changed because of undue influence or lack of mental capacity, give us a call, 740-374-5346, or visit our website, www.fieldsdemlo.com.